So, welcome everyone to our summer education and employment training series. We're excited to offer the 6 free webinars if you have joined us in the past. We designed these to be webinars that you can come on that will empower families, students, and professionals. And they're designed to provide you with tools and information to support success in school and beyond employment and day to day. So today is understanding your rights under the ADA and just a little bit of logistical, going over some of the things with your buttons. Actually, you know what? I'm sorry. I usually introduce myself. So my name's Tammy Sebastian. I am a special education advocate for Disability Rights Ohio. I use she, her pronouns. I am a white woman in my 50s, shoulder length, blonde hair, and I am joining you today from my home office. To support accessibility, today's session does include closed captioning that should be on the bottom right hand of your screen. And also the sessions will be recorded and posted on our website afterward. I believe Lindsay said that would be on our special education landing page. And I believe we're going to go ahead and put that in the chat as well. You're welcome to place your questions in the Q&A. We do have the chat closed, so please make sure you put your questions in the Q&A. If you are unable to put your questions in the Q&A, you can go ahead and use the raise your hand feature that should be in the middle of your screen. I'll be monitoring the Q&A throughout, and we also are reserving a little bit of time at the end if we don't get to your questions. So it is now my pleasure to introduce today's presenters, Melissa Day and David Kenninger. I knew I was going to. Kenninger, David Kenninger. So I will hand it over to you. Thank you.
Thank you. My name is Melissa Day, and I am a white woman with blonde hair past my shoulders. I'm wearing a black shirt and a headband in my hair, and I am coming to you from my home office today, and I use she, her pronouns. Next slide.
Whoop. And I'm going to introduce myself. I'm David Kenninger. I'm an attorney at Disability Rights Ohio in the CAP program. I'm a 60-year-old white male with long brown hair that's pulled back in a ponytail, and I'm wearing a pink shirt with a blue blazer, and I use he, him pronouns.
And I am an advocate with Disability Rights Ohio. And then Disability Rights Ohio is a nonprofit corporation with the mission to advocate for an equitable Ohio for people with disabilities. Our website is disabilityrightsohio.org, and our intake line number is 614-466-7264 or 1-800-282-9181. Next slide. Today's roadmap of what we're going to be talking about is, when does the Americans with Disabilities Act apply, which stands for ADA, or ADA stands for Americans with Disabilities Act. And then when to disclose your disability. So at the application process, before the interview, at the offer or after the offer, during employment. And then we'll be talking about, what does an accommodation mean under the Americans with Disabilities Act? Next slide. So the Americans with Disabilities Act is a federal law which protects employees with disability from discrimination on the basis of his or her disability. It applies to employers with 15 or more employees, so it protects most but not all employees. And in the state of Ohio, which is virtually identical to the ADA, it applies to 4 or more employees. And then there's also Section 504 of the Rehabilitation Act of 1973, which also protects employees with disabilities whose employers are recipients of federal funding. And the definition of disability is not based on one's diagnosis per se, but rather in which one's medical condition affects his or her disability, her life. And next slide. So the way the ADA defines an individual with a disability is the person has a physical or mental impairment that substantially limits a major life activity, and then has a record or history of a substantially limited impairment, or is regarded or perceived by an employer as having a substantially limited impairment. Next slide. So, talking about disclosure. Every job seeker with a disability is faced with the same decision. Should I or should I not disclose my disability? The decision often depends on whether you have a visible disability or an invisible disability. And the ultimate decision is entirely up to you. Next slide. So why do you disclose your disability? An employer is only required to provide work-related accommodations if you disclose your disability to the appropriate individuals. And the law requires that qualified applicants and employees with disabilities be provided reasonable accommodations. So in order to benefit from the ADA and the Rehabilitation Act, you must disclose your disability. Oh, there you go. So what do you disclose? There's no required information to share about your disability, but it can be helpful to share the following: general information about your disability, why you're disclosing your disability, how your disability affects your ability to perform key tasks of the job, the types of accommodations that have worked for you in the past, and types of accommodations you anticipate needing in that specific workplace. So an applicant is not required to disclose, and an employer generally may not require an applicant to disclose information about the disability or medical impairment prior to making an offer of employment, unless the applicant needs an accommodation to complete an early stage of the employment process. So in terms of the application, resume, and cover letter, if you need to disclose, if you use the TTY or voice relay for phone calls, or if your disability might be an asset and an asset to the position, disclosing might be helpful. You need to carefully consider where and how the information is presented. So for instance, your resume and cover letter should focus on and highlight your relevant skills and experiences, and you can make brief mention of your disability and your disability management skills. Usually on online applications now, there's a place where you can mark that you have a disability, and then if maybe further comment, you can say what accommodations you might need. So for the pre-interview, if you have a visible disability or need an accommodation for the interview, it's best to disclose your disability and accommodations prior to the scheduled interview, so the interviewer is prepared. To initiate that conversation, you might ask about accessibility or request accommodation when you ask about the interview location or directions. So is an employer allowed to ask disability-related questions or require medical examinations during an interview? No. So under the law, employers generally cannot ask disability-related questions or require medical examinations until after an applicant has been given a conditional job offer. So here are some examples of illegal questions and legal questions, and I'll go over those. So the illegal questions are, do you have any disabilities we should know about? Are you able to use your legs at all? Wrong. Do you have any pre-existing health conditions? Are you on any medication? How much do you weigh? Do you use drugs or alcohol? Then here are the legal questions they can ask. Can you perform the essential functions of the job with or without reasonable accommodation? Are you able to perform specific duties of the position? Are you able to lift boxes weighing up to 50 pounds? Are you able to reach items on a shelf that is 5 feet tall? And last one, in the past, have you been disciplined for violating company policies, permitting use or alcohol or illegal drugs? Next slide. Now, if you are asked an illegal question about your disability, you have 4 options. You can either briefly answer the question anyway, if you feel comfortable doing so. You can respond to the intent of the question. You can ignore the question and change the subject, or refuse to answer the question and then tell the interviewer that question does not seem to be legal or relevant to the specific requirements of the job. Next slide. So continuing on with when to disclose a disability. So after being offered the job, many people choose to disclose their disability after a job has been offered to ensure the employer will focus solely on the individual's qualifications and skills. If you know that you will need an accommodation, discuss it prior to the start date to ensure you have all the accommodations you need prior to arrival. Then the other option is during the course of employment. Say you don't think you need an accommodation, but you discover over time that you've underestimated your need for an accommodation. It's best to disclose your disability to your employer right away and ask for accommodations before your work performance is affected. So if an employer asks disability-related questions during post-offer stage, is the individual required to disclose his or her disability? So in this case, an employer may condition an offer of employment on the satisfactory condition of a medical questionnaire or an examination if the employer treats all successful applicants in the same way. So they must ask every single applicant that they perform a medical questionnaire examination. If an individual refuses to participate in examination, in this way, an employer may withdraw the offer. Next slide. And David's going to talk about reasonable accommodations.
Okay, thank you, Melissa. So Melissa got us through the the initial application and interview and job offer process. And so now I want to talk a little bit about reasonable accommodations and how those play out during the actual employment of the actual course of employment. So a reasonable accommodation is any change in the workplace or work environment or in the way things are customarily done that enables a person with a disability to perform the essential functions of his or her job. So again, the idea is that you're going to be able to perform the essential functions of the job, but you need some change in the work environment or perhaps some technology or something like that. So here are some examples. Someone with a wheelchair might need their office to be physically accessible. Someone with OCD might need a workspace that has fewer distractions, so they would request a separate office or walls around their desk. Someone with PTSD would request an exception to the policies or the rules of employer because they need to have a service animal with them. Someone who suffers from fatigue and works as a cashier might say, ask if they could have a stool to lean on while they're doing the cashier job. Someone who has just had a medical procedure or is returning to work after an injury might need additional leave time beyond the company policy or the FMLA. Someone else who, people vary. Some people, with vision issues might want less work time on a computer. Some people with anxiety issues might want less contact with the public. So the request would be for some alteration in the way that the job works, or even assignment to a different job to enable them to be able to do work in an environment that's more comfortable to them. Sort of one of the basic factors behind a reasonable accommodation is that you're saying to the employer, you can't have an across-the-board policy that requires everyone to do the same thing, or you can't say, well, that's the way we've always done it, because the whole idea is that you're going to do something a little bit differently to eliminate the barrier for the person who has the disability that needs the accommodation. So a request for accommodation should initiate what's known as the interactive process. And in this process, the employee and employer ideally work together to decide what help the employee needs to perform the essential functions of the job. So if you as the employee request a specific accommodation, the employer can offer a different accommodation as long as that accommodation will be effective. So you might request a specific thing that, a specific way, to have your office set up or something like that. But your employer is entitled to come back and say, well, that might work, but I'd like to do this because it's cheaper, or I think it'll be more effective, or it, fits with our office space better. They're allowed to come back and say that. And that's fine. Again, the process should be interactive and the parties should be working together. But that means that if you decide that, your employer decides they want to try something other than what you've suggested, that you need to monitor the accommodation. And if that's not working out, if it's not effective, then you have the right to ask for something else. And you may need to bring in some information from your doctor to explain why the particular accommodation that your employer's offered hasn't been working or won't work, in order to justify your continuing request for the specific accommodation that you wanted. And so it's really important that there be back and forth in this process, but that isn't what always happens. And so sometimes an employer will simply, ignore the request, or, have a flat no and say, nope, company policy says this, we don't vary it, which is not legal, but there's nothing in the ADA that actually requires employers to engage in the process. A good employer should engage in the process because they want to eliminate barriers for their employees to do good work. But if they don't, that can be some evidence of disability discrimination if you're in a situation down the road where you filed a complaint because of the way you've been treated. So an employer also does not have to implement an accommodation if it can show that implementing the accommodation would impose what's called undue hardship. And undue hardship means an action requiring significant difficulty or expense when considered in light of the following factors. And these factors are all sort of employer specific. So a lot of this is resolved or addressed on a case-by-case basis. And one of the big factors is sort of how big or how complicated is the business that you're involved with. So there's the nature and the cost of the accommodation needed. Now, there's an entity known as the Job Accommodation Network. We have some information about them in a later slide. That is part of the Department of Labor. And they've done studies to show that the average cost of an accommodation is something like $300 or less. So generally speaking, cost should not be a barrier to most employers. But again, the overall financial resources of the facility or facilities involved can be a factor. The number of persons employed at the facility, the effect on expenses and resources, or the impact otherwise of the accommodation on the operation of the facility. Again, depending on the scope of the accommodation that's requested, the size of the employer, think about, are you working for Amazon, which has, thousands of employees and work sites all over the place with lots and lots of people? Or are you talking about, an entity that's a local business? The overall financial resources, again, thinking big versus smaller, Amazon versus something more local. The financial resources, the overall size of the business with respect to the number of employees, the number, type, and location of its facilities. Is it one store, or is it a chain of thousands? And again, the type of operations. What kind of work are you doing? Is it a factory setup? Is it are there a number of hazards, or is it a retail store? What kinds of things? The geographic separateness, the administrative or fiscal relationship of the facility to the covered entity, and so on. So there's a whole variety of factors that come into play about how the request for accommodation should whether it can create an undue hardship. But again, if you're thinking about finances, most accommodations don't cost very much money, are not a significant burden for most employers. And many employers, especially large ones, can afford to make a change in their policy or pay for an accommodation. So again, we're back to the question of disclosure. Do you have to disclose or request an accommodation at a certain time? And the answer is no. You can request an accommodation at any time. As Melissa was saying, you may need that if you are trying to apply online and need an accommodation to be able to apply because you can't apply online or something like that, or you need assistance during the interview process. All of that is a fine time to request an accommodation. But if you don't, you start into the job, then you'll know to disclose and request an accommodation when it becomes apparent if you're having trouble performing your job duties because of your disability. But the idea here is to be proactive. Don't let it get to the point where you know that you're not doing the job or you're not doing a good job because you need an accommodation. There's a barrier to you doing the essential functions of the job. So, but don't worry that you didn't disclose when you were being hired. You didn't disclose, you were hired, you start working at the job, you realize there's something that you need to help you do the essential functions of the job. That's the time to disclose before you have a performance issue. And request the accommodation, get in that interactive process, and try to work something out with your employer. And again, according to the EEOC, it's usually in everyone's best interest to request the accommodation before any conduct problems occur. So what are you required to disclose when you're requesting accommodation? Well, there's no formal guidance. Many employees prefer not to disclose their diagnosis because they don't want to be stereotyped, and that's understandable and natural. Now, under the ADA, employers may be able to insist on knowing the name of the impairment as part of determining whether the employee has a covered disability. So we go back to the definition of disability. What is the particular condition that imposes the limitations on your ability to do the essential functions of the job? But remember, the disclosure does not have to be to everyone at the employer, only to the appropriate people. So it's almost certainly to the HR department, maybe to a director or head of the agency or regional manager, something like that, not necessarily to your supervisor. Supervisor might not need to know all the specifics, but only the limitations that require the accommodation and require them to do something out of the ordinary to accommodate you to get so that you can do your work. But as far as the specifics, you don't need to give every detail. And you might want to begin by just giving a general description. For example, I have a mental health impairment, or I have a condition that affects my immune system. There are a variety of conditions that affect your immune system, so you don't necessarily need to spell out what that is. But in some situations, it is true that a limited description might not be sufficient to describe your impairment or your limitations or your need for an accommodation. One of the things we often tell clients is that it's helpful to have some information from your doctor that specifies what the limitations are and what the best way to accommodate those limitations in the particular workspace would be. Now, that's not always possible to get something quite that specific from a doctor, but that's sort of the goal, to make sure that your employer understands that these limitations are a direct consequence of your having a particular disability or condition, and that there are certain things that you need in the environment to do the essential functions of the job. But once you have those things, you can do the job. So an employer can request reasonable documentation to determine that you have a covered disability for which you need a reasonable accommodation. So if an employee discloses a disability in response to a poor performance evaluation or is disciplined for unacceptable conduct? Is an employer required to change the evaluation or to withhold the disciplinary action? And the answer is no. This presumes that there was no disclosure prior to the poor evaluation. So if there's no disclosure, and again, this is why we say be proactive. Your employer can hold you accountable under the same performance and conduct standards as they would any employees without disabilities. So if, again, if you feel that that your disability is causing you to not meet performance standards or to not be able to do some part of the job that you know needs to be done, and you know your performance is not good, you need to ask for the accommodation then before there's something issued in terms of a disciplinary action or an unacceptable evaluation. So if the disability is disclosed and is requested, if you weren't able to be proactive and you now realize that the reason why you haven't been able to do all that's required of the job is because of a disability, well, that still gives you some space to request an accommodation with the employer and to work with the employer to sort of have a bit of that interactive process to try to figure out how the disability affected your performance, how you can fix that, what accommodations you might need to meet the standards. Because if you had a bad evaluation and you're maybe on a performance improvement plan, you want to be able to perform. So at that point, you should be able to still talk about accommodations and try to improve that performance so that you can stay in the job. Okay, so what if you disclose your disability and receive reasonable accommodations, but new management doesn't acknowledge it? So we often say that some of the worst news that our clients can get is you have a new supervisor, because what has sometimes happens is that someone will be working along and their supervisor might know about their disability and might have already arranged accommodations. Maybe they've done it formally through company policy. Maybe they've done it informally, just an agreement between the two people, because again, there doesn't necessarily need to be the whole company that knows, except that when that new supervisor comes in, they might not know about the accommodation. They might not validate the agreement. They might think that that company policy applies across the board and no accommodation is required. Well, if something like that happens, then that's the time to contact the Human Resources Department, because again, they're the folks who are the appropriate recipients of any request for accommodation. So if you had an informal accommodation but nothing formal, send that formal accommodation request to Human Resources right away. Provide the doctor's information to support it. Make that request and see if you can't get Human Resources to reinstate those accommodations. If you're in a union, you could also speak to your union representative about making sure that company rules are followed in terms of evaluating and supporting a reasonable accommodation. And if none of that works, they're still saying, you can't have the accommodations that you previously had. By all means, contact us at Disability Rights Ohio. You'll see our contact information in a minute, and consider filing a charge of discrimination. So we've gone through all the steps of the employment process, from application to interview to hiring and orientation and employment and requesting reasonable accommodations. If you go through all that and find that you are being treated adversely, you've been fired or demoted or not promoted or cannot or not provide a reasonable accommodation, that you need to do the work or that you need to do the work comfortably. Sometimes some people are able, though they have a disability, to do the job, but it's incredibly painful or upsetting for them to do it in the way that the employer wants them to do, or that they've been put in a harassing environment because they made a request, or that they haven't been provided equal pay or benefits. All of those things are potential employment discrimination. And so there are two main administrative agencies that you can go to that have jurisdiction to investigate charges of employment discrimination. And in Ohio, the state entity is the Ohio Civil Rights Commission, and at the federal level, it's the Federal Equal Employment Opportunities Commission. And it's important to know that in order to bring a lawsuit under the ADA, you have to first file a charge of discrimination with either of these agencies. And there's a deadline. The deadline to file a charge of discrimination with the Civil Rights Commission is with 180 days of the last alleged discriminatory act, or for the EEOC within 300 days of the discriminatory act. And there's information here, which you'll be able to pull through on the slides about how to file a charge with the OCRC and with the EEOC. And there are also some resources that we can point out to you. The EEOC has information about job applicants and the ADA. The Job Accommodations Network has a variety of information about every step of the employment process, from application to interview to reasonable accommodation to leave to work from home to a whole variety of things. So it's a terrific resource that provides information to both employers and employees about how to do the interactive process and about how to accommodate disability in the workplace. And finally, Disability Rights Ohio has our information on our website as well about filing an employment discrimination complaint and walking you through all the parts of it as in terms of your rights and remedies if you've been discriminated against. So that's the information that we have. Here's our contact information if you need to reach us. And we are open for questions if anybody has questions.
There are no questions in the Q&A, but now would be a great time because we have some time to go ahead and think of those questions, put them in the Q&A, raise your hand. Okay, well, I don't know. You guys just probably did a really, oh, here, yay, I got a question.
Hooray.
Has OCR, Office of Civil Rights, been given authority to take disability complaints? It looks like the question got cut off, but it said recently I tried maybe to file a complaint.
Yes, OCRC should be able to receive a disability discrimination complaint. It's part of it's ORC, what is it, 4112, I believe, in the Ohio Revised Code that provides protection against discrimination in employment for people with disabilities.
Okay, yes, and I think they expanded. Yes, to file a complaint, was told they were not given authority by the legislator.
Now, one potential exception is if you're employed by a state employer, there may be an internal administrative process that you would need to go through first, but you would still be able to ultimately to file an OCRC complaint, I believe.
And you could contact our office and we can provide you with, if you don't know the internal way to file a complaint, we can help you, find that process for you.
Yeah, that's a fine opportunity to contact us and we can sort through it with you and figure out what they're telling you.
Great. Another question, are employers still allowed to claim? I'm not sure if don't disclose, claim lie. I'm not sure, but I'm not sure what they're asking. Could you type in there? I'm not sure if there's a word that's off, but it says, are employers still allowed to claim lied if don't disclose in the interview? I'm not sure.
I think the idea might be, are they allowed to say that you lied if you didn't disclose? And
yes, that's what it is, David.
So, yeah, I don't know, Melissa, do you want to take that one? Or?
No, I don't believe they can't accuse you of lying, and that you have a right to disclose, anytime during the process of your employment. Now, if you needed an accommodation during the interview process, you would want to tell them then, but they still can accuse you of lying about it. You're saying you have medical documentation, or here's the law, and use our resources on our website to show them, or contact our office and we can provide you with additional resources to provide the employer that this is what the law says.
Yeah, I mean, I think the law is pretty clear that you don't have to disclose up front and that you can initiate a reasonable accommodation process at any time. So there shouldn't be any sort of accusation that that you lied.
Okay. Well, does not look like there's any more questions in the chat. Oh, just as I said that,
Aha.
another one pop up. It said fairly recently, disability rights stated did not have resources to file complaints. Has that changed?
I'm afraid that it hasn't changed. That primarily our ability is to provide information and referrals. We encourage folks to we provide information to folks to help them engage in self-advocacy and file their complaints with the OCRC and the EOC, but we are not able to represent them in complaints at this time.
Okay. Well, Melissa and David, thank you so much. That was great information. And I know we'll be seeing you again. I just want to let everybody know thank you for joining us today. And we hope that you found this information helpful and that you're leaving with some practical tools and information and insights that you can move forward with.
Tammy, can I
yes.
interrupt you briefly? There's
Yeah.
just one more statement in the Q&A, and that is
I see that.
we need attorneys, please. David, could you just provide a little bit of information about a potential referral where people could find a referral to an attorney for this kind of an issue?
Sure. Well, the Ohio Employment Lawyers Association is an entity that an entity composed of lawyers who represent individual employees in cases against their employers. And they are a good source of potential referrals for an appropriate discrimination complaint. So I would look there, and I think their website is ohiooela.org, but I'm not positive. So I don't want to lead anyone to the wrong website. But if you Google Ohio Employment Lawyers Association, you should be able to find them. And that's where I would turn. There are lawyers all around the state of Ohio who do this kind of work on behalf of individual employees all the time. And they may be able to do a consult and either provide advice or potentially take on a case for representation.
Perfect. Thank you, David. So, and with that being said, if you do have questions that come up after today's training and you need to reach out, please don't hesitate to reach out to us. We're always happy to support you further. And as a reminder, again, today's session was recorded and will be posted to our website soon. Feel free to revisit it or share it with others who may benefit from it. And we hope you will join us for the next session in this series. I believe we are going to, David and Melissa will be back for What is CAP? And so that will be on August 26th. So we hope you enjoyed today's training. Please come back and see us next week. Thank you all. Take care.
Thank you. Take care.
Bye-bye.